Welcome to Off the Record, Personal Injury Litigation with Michael Kopsick.
Hello and welcome back to Off the Record, Personal Injury Litigation with Michael Kopsick. Michael is a trial-tested Illinois injury lawyer who has taken more than 60 cases to verdict and handled thousands of depositions, including hundreds involving doctors and experts. He brings a clear, straightforward approach to explaining how the law actually treats injured people. My name is Kevin Rosenquist, and today we're talking about whether or not a pre-existing condition like back pain, arthritis, or a past injury ruins your case, or if it can still be a strong claim under Illinois law. Michael, welcome back. It's good to see you.
Thanks so much. Yeah, good to see you as well.
So for someone hearing this topic for the first time, how do you explain what a pre-existing condition means in the context of an Illinois injury case?
Yeah, well, pre-existing conditions or pre-existing injuries typically are only relevant when you're discussing where on the body the client is currently injured or what injuries we're claiming. So for instance, if there is a lower back injury that we're claiming occurred as a result of this incident, and the client had a pre-existing lower back injury, that would be relevant and relevant in a conversation moving forward. So it's not just that someone has a pre-existing condition, it's typically reserved for the same part of the body in that context.
So I imagine you have to consider a client's medical history, obviously, when you're evaluating a new matter. What makes a case straightforward and ideal versus one that might require more careful work?
Yeah, ideal would be no pre-existing conditions ever.
I suppose
right?
So.
Yeah,
you've been the healthiest person ever.
Exactly, right? I mean, I hate to say this out loud, but you really want a young client. You really want someone who's never had a traumatic incident or accident. You want someone who's never had a surgery before. But, as you might imagine, those are very few and far between clients and cases. The older you get, the worse your MRIs look, right? Even if you haven't had a traumatic incident or accident, just the wear and tear that someone might go through. Maybe they were an athlete, maybe they were some type of, a runner or triathlon type person, and that type of activity over the course of time can really wear someone down. So ideally, you'd like to see no injuries, but the reality is a lot of people get banged up along the way.
Yeah, absolutely. I mean, like you said, no matter what you do, you could skateboard, you could do anything. I mean, there's all sorts of different stuff that you can get hurt at. So yeah, I understand what you mean there. So do prior injuries automatically weaken a case?
No, and it's funny you ask because it's really a question for the plaintiff's attorney. He might go one way, the defense attorney might go another way. There's obviously always going to be competing opinions here. So there's always a way to get around pre-existing conditions. Like we said, it's not ideal, but we have to take our plaintiff as they are. And like we said, there's many different places and ways we can find our plaintiff in and the condition we find our clients in. And we have to be able to adapt and we have to be able to have an argument prepared. So if you're asking a plaintiff, no, a pre-existing condition is not that big of a deal. What we have to do is be able to show a timeline of their past injuries, when the accident happened, and what happened thereafter. We generally would love to see a big timeline, right? So pre-existing back injuries, lower back injuries, for instance, let's say those injuries stop being symptomatic. The plaintiff was not feeling any issues or any pain for a period of 5 years, and then the accident happened. Does the plaintiff have pre-existing conditions? Yes, but they've been asymptomatic for 5 years. So there's a way to argue around that. And what you see are really some tough issues, some tough arguments to create as the timeline gets shorter and shorter or kind of crunched tighter and tighter. If someone was injured and experiencing symptoms 2 weeks before this accident, that might not be a case that we want to take, or if we do, we're going to have some problems.
Right, yeah. Will the insurance companies still try to kind of push, even if it's like, I don't know, it doesn't seem like a super relevant injury, or maybe it was a long time ago? Will they just try to find anything they can, or is there a certain distance back they're going to go?
Yeah, they are going to look for anything and everything. We like to say that they want to throw up spaghetti on the wall and see what sticks, right? They want to find any pre-existing condition. They want to find any history of any accident, any prior surgery, even if it was 10, 15, 20 years ago. That does not matter to an insurance company. That certainly does not matter to a defense attorney who is trying to present an argument to a juror or a jury. He or she is trying to make the plaintiff look as injured as possible, as kind of malingering and complaining as humanly possible. So there's really no holds bar when it comes to defense attorneys trying to make some type of an argument.
I know, so Illinois law says a defendant must take a person as they find them. What does that exactly mean?
Yeah, well, we call it the eggshell plaintiff theory. That's how a lot of people refer to it. And the reality is what we learn in law school, and I can remember the lesson that was taught by our torts teacher, is if someone has brittle bone disease, for instance, and you get hit by a baseball, someone throws a baseball at that person on purpose, trying to hurt them. Well, if I got hit with a baseball on my shoulder and I don't have brittle bone disease, nothing would happen. Maybe I'd get a bruise or something like that. But with the plaintiff who has brittle bone disease, for instance, they're an eggshell plaintiff, meaning their bones are going to break or something really bad is going to happen to that person, where it might not necessarily happen to the 999 other people out of 1,000. But the law says we have to take every plaintiff as they are. And whether they have a bone disease, whether they have a pre-existing condition, for instance, that should not be held against them in a jury trial and not held against them in terms of valuation of the case or settlement.
Okay. Yeah, that makes sense. That seems fair. I mean, that's not fair for somebody to have to be held to the same standards as someone who might be who wouldn't have that brittle bone disease that you spoke of.
Right. Yeah. It's, you shouldn't hold it against someone if they were in a previous car accident 10 years ago and they have chronic back pain. Just because someone has chronic back pain doesn't necessarily mean that they weren't injured in this accident, right? So again, going back to what we were talking about, defense attorneys, they're going to want to take anything and everything and find that accident and find that injury, find that surgery. But the reality is we have specific instructions to show a jury. We have case law that is very supportive of the fact that we take plaintiffs as they are. And it's a concept that defense attorneys don't like to admit to, they don't like to acknowledge, but it's the reality. And that's what the law says.
That's the law. Yeah. Yeah. So when the case goes to trial, how do jurors generally react to pre-existing conditions? What matters most to them?
Yeah, I mean, I think jurors tend to side with defense attorneys, right? We have to always go back to the fact, and we spoke about this on our first episode, that jurors don't want to be there in the first place. I mean, truly, they have kids, they have jobs. They have obligations, and they're getting paid $25 a day to be there, and nobody cares about a plaintiff. Now, of course, there are exceptions to someone who's paralyzed or someone who dies. That will get the attention of a jury, but the run-of-the-mill case that you see in personal injury law, nobody really cares. So the more negative things that someone brings into evidence about the plaintiff and about their history, like pre-existing conditions or like a nagging injury that has been symptomatic, that the plaintiff has history and medical treatment with respect to that injury, jurors certainly like to hold that against the plaintiff, because at the end of the day, we're asking for a large amount of money, and we're asking a juror who doesn't want to be there, who's missing time away from their family and their job, to award a large sum of money. And if we don't have a clean case, if we don't have a nice, clean timeline with no pre-existing conditions, they're certainly going to use that against us.
Obviously, the defense knows that. So does that, in those situations, are they more prone to going to trying to push to go to trial because of that?
For sure. Yeah. For sure. Right. And we might have a case with respect to liability that's a slam dunk. Maybe it's a rear end car accident. We, as a plaintiff, we're going to win that case 99 times out of 100. Only something crazy could happen where we would lose one of those types of cases, like a rear end car accident. But the defense wants to try cases where the medical records are muddied up, where the history and the timeline is muddied up. And they do a good job, some of them at least do a good job of muddying the waters and kind of bringing things to light that aren't necessarily relevant, right? From our perspective, we don't think a pre-existing condition is automatically relevant unless the pre-existing conditions are being complained about very close in time to this accident and these kind of new or fresh injuries. But from a defense perspective, they don't care. They want the jury to hear about it. They want the jury to read about it, to see exhibits about it, and hoping that one of those jurors kind of gloms on to that awful argument that they're making. And sometimes it works, unfortunately, for the plaintiff.
Mm-hmm. Even though the law says, the defendant must take a person as they find them, the jury, does that not really resonate with the jury, you think?
I don't think so. Not all the time. And the reason is, we're talking about a jury instruction. So for those of the listeners out there who don't know, once a case is completed and once the evidence is in, the judge reads a series of jury instructions to every single juror. And when the trial's over, it's honestly one of the most boring things that you could ever be a part of, because all the adrenaline, as far as my closing argument, has just worn off. I'm sweating, I'm excited, and we have this hour and a half period sometimes where a judge is just reading page after page after page. And sometimes the cases can be so complex where it takes, over an hour of the judge reading each and every instruction. And it's very formal, it's very tedious, and I'll admit it's incredibly boring. And that's coming from an attorney's perspective. Mm-hmm. So you have to imagine a layperson, let's say a construction worker who's on our jury, or a school teacher. Again, they don't want to be here, and they certainly don't want a judge to read 53 some odd pages of jury instructions. So to answer your question, does it get lost on a juror? Absolutely. Because it's 3 sentences of, a 30-minute or 40-minute or 50-minute period of time where the judge is just throwing up and regurgitating and vomiting the law and the instructions. And people probably aren't listening. They are ready to get out of that trial, to get to their verdict, to get in their car and go home. So, as a part of my closing argument and a part of what I tell a jury before they go back to the jury room to start to review the case, I make sure I hammer this jury instruction. Say, hey, I want you to listen very carefully to me. I want you to pay attention to, I think it's jury instruction IPI 30.21, which is in the damages section. Listen to this. The defense attorney is going to talk about pre-existing conditions. The defense attorney is going to talk about how we are not as injured as we say. Pay close attention and take this jury instruction and use it if anyone in that jury box is saying that we had a pre-existing condition and we should hold that against the plaintiff. Use this instruction. Use 30.21. So you try to drive it home. You try to use it to your advantage. But the reality is it sometimes gets lost in translation.
Absolutely. Yeah, I believe it. How do you explain to the jurors then, how do you counter that? How do you explain the difference between what existed before and what actually aggravated or was made worse by the accident?
Well, you highlight all of the facts that help your case. And like going back to the timeline conversation, if there is a year or 2 or 3 years that have gone by with no complaints, no medical treatment, I might spend 5, 6, 7 minutes on that one fact alone or that one argument. They want to talk about pre-existing conditions. What happened in 2020? What happened in 2021? What happened in 2022? No medical treatment, no symptoms, no complaints, no doctor's appointments, no diagnoses, no nothing. Just because someone had a prior back injury does not mean that they were not injured in this accident. So we hammer home the timeline over and over and over again. And you make the defense look bad sometimes. You say they want to have a smoke and mirrors situation. They want to put a rug over your eyes and pretend like something has happened, which it did not happen. It's not actually going that way when you lay out the facts and the months and the years as we like to do. So you hammer it as much as you can, but again, sometimes the jurors like to cling on to those facts that ultimately make for a reduced verdict.
That's interesting about those facts is without giving away any trade secrets, so there are certain ways that you try to, lean on facts that jurors will understand, because, certain things obviously are going to resonate with different people. If this person had some issues beforehand, the plaintiff had some issues beforehand, what do you lean on to show that that's not the case?
Well, besides argument, if I'm asking the plaintiff a question in examination, or oftentimes what I think is really effective when we have expert opinions that come through in evidence deposition transcripts, and very quickly, sometimes doctors don't testify live at trial. Sometimes we have their testimony on a transcript before trial so as to not inconvenience that doctor. When that takes place, I have to physically read the questions, and I have somebody who kind of pretends to be the witness on the stand reading the transcript and giving the answers. So what I like to do is I like to really emphasize the questions when the jury is listening, as opposed to just reading off the paper. I'll do something along the lines of, and just to be clear, doctor, in the 3 years before this accident, plaintiff did not complain one time. Is that true, doctor? And I will really go probably way too far overboard to emphasize, to stare the jury in the eyes, to make sure they understand I'm hammering home this point and this question. Now, that's not how I phrased the question in the evidence deposition that led to this transcript, but you better believe that's how I'm going to phrase it, and that's how I'm going to emphasize it at trial when it really matters.
As we finish up today, if for anyone out there who might have what you might consider a complicated medical history, maybe perhaps they had a lot of injuries, things like that, what should they know? What should they focus on early in the process after an accident to make sure that everything is documented clearly, handled the right way, and whatnot?
Well, first and foremost, I would say, first of all, don't worry that you have pre-existing conditions, and don't let that be an impediment to hiring an attorney. Just because someone has complex medical history, we will be able to sidestep any problems, any landmines, any impediments. That's what we do. No case is perfect, no facts are perfect, and the attorney will be able to adjust and improvise accordingly. That's really what's most important. But what you can do, and you alluded to it already, is when you're with the doctor with these new injuries, ask them to document it properly. Make sure you front the issue. And that's a legal phrase, but fronting a problem is getting out ahead of a problem and letting a jury know, or letting the doctor know, hey, look, I've had this problem in the past. I'm not trying to hide it. I'm trying to get out in front of it. If you want to put, Dr. Smith, that I was involved in a car accident 10 years ago, go ahead. But make sure you write in there that I've had no symptoms, I've had no complaints, I've had no treatment to that effect. So we're not going to hide from it. We're not going to cover it up. We're certainly not going to lie. We're going to get out in front of the problem, but we're going to make sure the doctor documents the medical records properly. And sometimes that's just having some advocacy for yourself, letting the doctor know, here's what my issue is, and hoping that the doctor will note your records accordingly.
That's great advice. I think it makes a lot of sense. All right, well, that's it for today's episode of Off the Record Personal Injury Litigation with Michael Kopsick. To learn more about Michael's work representing injured people, visit law-mwk.com. Thanks for tuning in. Don't forget to like, subscribe, share the episode with someone who might need it. We'd really appreciate that. Michael, it's always great chatting with you. Thanks so much.
My pleasure. Thanks so much.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.